president cannot bypass the courts, and yet that's exactly what he's been trying to do, tells us law professor Josh Blackman, a constitutional law professor at South Texas College of Law in Houston. In a provocative op-ed in the New York Times, University of Chicago law professor William Bowdy argues the president has the power to sidestep the Supreme Court if it rules against him on Obamacare. See, this is part of the problem. We have these crackpot, lunatic, fringe, left extremist radical individuals dressed up as professors and law professors who come up with the most bizarre arguments, and then they become law. In King v. Burwell, in full disclosure, Landmark Legal Foundation and I are fully involved in this case, which I believe we have, our filing has been posted on landmarklegal.org. But here's the point. In that case, 4 Virginians claim they're injured by what they describe as the administration's illegal payment of Obamacare subsidies. Now, this Professor Bowdy offers an easy way out for Obama. Quote, if the administration loses in King, he suggests, it can announce that it's complying with the Supreme Court's judgment, but only with respect to the 4 plaintiffs who brought the suit. How clever, huh? Professor Bowdy explains that the Supreme Court's formal power is limited to ordering a remedy only for the 4 people actually before it. I see. So in those famous contraceptive cases in 1965 that were all brought together and brought to the Supreme Court, really the court was only ruling on that particular couple and their condoms and their foam. Don't blame me, that's what it was about. That's all. Didn't have to do with privacy rights, and same with abortion. When the Supreme Court ruled in Roe v. Wade, it was ruling in one case about one woman and one fetus. Right, Professor? You moron. But I digress. Let's continue. In offering this get-out-of-jail-free card to the Obama administration, this Professor Bowdy notes that the Constitution supplies a contingency plan, even if the administration doesn't know it yet. Alas, the Obama Justice Department is well aware of this stratagem to bypass the federal courts. It has thrice plotted this procedural push. That's 3 times. In 3 high-profile cases, 2 involving Obamacare and 1 involving immigration, the Obama Justice Department has openly challenged the power of federal courts to issue nationwide injunctions to halt unlawful executive actions. These desperate efforts to interfere with the courts in order to salvage unprecedented assertions of power have flouted the rule of law. And you've heard the screaming by the leftist journalists all over TV, haven't you? Saying, wait a minute, this president can't flout the law. He can't ignore the courts. Haven't you heard that? I think it's all over MSLSD. By the way, as an experiment, I literally spent 2 hours today watching CNN. From about 1:30 to 3:30, maybe it was 2 to 4. What a complete and utter disgrace. 100% Obama, 100% anti-Netanyahu. It's just a propaganda mill for Obama. No wonder nobody watches CNN. It's absolutely appalling. Anyway, let's look at these cases briefly, shall we? January 2011, federal judge Roger Vincent in Tallahassee found that Obamacare's individual mandate was unconstitutional. Too bad he wasn't the Chief Justice of the Supreme Court, by the way. And he invalidated the entire law. 2 weeks later, the Obama administration filed what's known as a motion for clarification, asking the court to explain whether the United States could continue to take steps to implement Obamacare while the case was being appealed. Now talk about chutzpah. Chutzpah. That's the same damn thing they're doing in Texas with immigration, because this is Obama. Obama's figuring, all right, let's move fast. Let's move as many people, as many dollars as we can in the direction I want to take this country. And by the time the court's here, further cases, further arguments, it's too late. Then they have to undo everything. Then we can run around and say, see, there's 6 million people on Obamacare. What are you going to do about that? See, there's 4.5 million illegal aliens receiving Social Security. What are you going to do? Take it from them? Then we'll hear from idiots like Ruth Bader Ginsburg going on TV and on radio and other interviews saying what? But what else is she saying? She's saying things like, what are we going to do? And we're gonna take the benefits away from these people who had the benefits. Anyway, there you have, lifetime appointment. He goes on. He says a former Department of Justice attorney explained that Judge Vincent's order, quote, was framed with such breadth that it would be incredibly disruptive with regard to the portions of the act that were already in force. Get it? So the government would not even have been able to comply with the order, the lawyer said. So he speculated Vincent didn't appreciate the full consequences of his order. So they want to create a scenario where a court upholding the Constitution or a statute creates such disruption and disorder because we're so far down the road on tyranny, consolidation, big government, spending, taxes, borrowing on behalf of an unconstitutional initiative. Well, what's the judge want to do? Undo all our good works? Judge Vincent was none too pleased with the request, which he saw as a pointless delay. But here's another example. Just last year, March of 2014, the administration repeated its claim that a single federal court could not stop Obamacare. The week before, oral arguments were held in a case called Halbig versus Burwell in the D.C. Circuit Court of Appeals. The Justice Department submitted a letter informing the judges that they were constitutionally prohibited from denying subsidies to millions of Americans. In short, the government argued that people who were not parties to the suit had a due process right to be heard before their subsidies were extinguished, as if Obamacare were some sort of constitutionally protected property interest. By the way, try that argument if you want to challenge the unconstitutionality of some action by the Internal Revenue Service and see if you have standing. Hey, I'm a citizen, I have due process. You'll be thrown out in 2 seconds. So the plaintiff shot back at the Obama administration in court. Incredulous, the government had an apparent intention to lawlessly flout the court's binding order, they said. In August, the D.C. Circuit ruled for the plaintiffs and sent the case back to the lower court with instructions to vacate the IRS rule in its entirety. By the way, that was that panel on the D.C. Circuit. So you know what Obama did to change that? Harry Reid created 3 more seats on the D.C. Circuit Court of Appeals. Harry Reid suspended the filibuster rule as applies to lower court nominations. The Democrats stuffed 3 radical leftists into those positions on the D.C. Court of Appeals. Then the Obama administration said to the court, we want the whole court to hear the case. En banc, that means. The whole court, not just this panel with these 2 right-wing kooks on it. No, we want the whole court to hear it, because now we control the court. We stuffed it with leftists. And that court was going to hear the case, but oops, the Supreme Court reached down and said, no, we'll take it. You sit still. That's the Obamacare case that's in the court now. But I'm trying to explain the extent to which Obama is destroying the judiciary and defying the judiciary, and how the judiciary is having difficulty keeping up with him, just as Congress has no ability to keep up with him, even if it wanted to, because he's one man on a mission. He doesn't have to worry about due process. He doesn't have to worry about motions hearings. He doesn't have to worry about filing cases. He doesn't have to worry about pulling together a majority in the House and a supermajority in the Senate. He issues an executive order. He issues a fiat. He has his bureaucracy issue thousands and thousands of regulations every single year, and they're on offense, and nobody can catch up with them. It's a huge problem, which is exactly why you should consider what I wrote in the Liberty Amendments, my last book. But I'm not here to hawk that. I'm here to explain now what's going on. And it'll be explained tomorrow, next week, or next month by others who will do their best but will fail. So I want you to listen to these things so we can understand this Constitution belongs to us. This system belongs to us, not Barack Obama. And the last case we have is the immigration case before a really terrific judge who they started trashing immediately, Judge Andrew Hannon. And last month in Brownsville, Texas, he found Obama's most recent executive action on immigration, the Deferred Action for Parental Accountability, unlawful. And the suit was brought on behalf of 26 states by the Solicitor of Texas. And it sought to halt the implementation of this executive unconstitutional amnesty in its entirety. And Judge Andrew Hannon agreed and issued a nationwide injunction. So true to form, what did the Justice Department do, folks? It went to that judge and it said, you don't have the power to issue a nationwide injunction. Nationwide injunctive relief is particularly inappropriate in the context of government programs. And so in their filing with the circuit court above this judge, They called this lower court judge's decision drastically overbroad and manifestly excessive, as it enjoined the Department of Homeland Security from implementing the guidance nationwide, barring implementation in states that do not oppose it and in states that support it. Isn't it amazing? This administration arguing for nullification, this administration in court arguing for federalism. Isn't it amazing? This administration arguing against judicial review. And of course, we know that in the past, the left has used the courts and abused the courts to advance their agenda when they couldn't get it at the ballot box. So, Professor Josh Blackman points out, in these three significant cases, the government strategy has become apparent. In the first case, they argue that Obamacare was too big to stop, that a single federal court in Florida couldn't stop it. The second case, it openly expressed its desire to flout the court's ruling on the grounds a single federal court couldn't issue relief, but only to the parties before it. In the third case, the immigration case, it claimed that a single federal judge was powerless to stop Obama and powerless to stop his unconstitutional amnesty. And Obama's hoping the same argument will work in the Supreme Court. And as a matter of fact, he's being urged by radical left-wing professors that regardless of what the Supreme Court rules, Obama should claim that the ruling only applies to the plaintiffs who are before the court in the Obamacare case, only to four parties, but Obamacare can go forward with respect to everybody else in the nation. We are confronting, looking in the eyes of tyranny. And the surrogates for tyranny, the lawyers for tyranny, the politicians for tyranny, and the journalists for tyranny. And this is no joke.